Okay, good morning to all. Today we are going to discuss a case law from the MSME Act. This case is relating to who can file a case before the MSME Council. Whether the case can be filed by the buyer or by a supplier only. If you see section 15 to 18, the case says that the supplier whose payment is delayed, then the supplier only can file the case. What happened in this matter is the buyer has filed a case. It was also accepted by the MSE Council, agreed by this order. The supplier filed a case before the High Court. And the High Court, after going to the relevant provisions of the MSME Act, has said that only the supplier has the right to file the case before the MSME Council, not the other way around. So, this is the order passed by the Honorable Delhi High Court. Let us see what is the case. Go into the case. The case is between Uni7 Engineering and Infrastructure Private Limited versus MSE Council District. Observation is that MSE Facilitation Council cannot entertain independent claims at the instant of the buyer against the supplier. The parties enter into, in this case, the party entered into an agreement dated 17/10/2019. Under the contract, the petitioner was to supply goods and services, including labor, material, tools, etc., as also engineers and supervisors for monitoring services to the respondent. A dispute arose between the parties regarding the payments under the agreements. Accordingly, the respondent issued a legal notice to the petitioner. Thereafter, the respondent encashed the bank guarantee issued by the petitioner. The respondent also terminated the agreement, citing non-performance by the petitioner. Thereafter, the respondent, who is a buyer, preferred a claim before the MSE Council under Section 18 of the MSME Act. Consequently, the Council, by its order dated 14/9/2021, advised the petitioner to pay to the respondent a sum of rupees 9,59,352 rupees, agreed by the order of the MSE Council directing to make the payment to the supplier. The supplier filed an appeal, that is, made an appeal before the Delhi High Court. Okay, in a writ petition challenging the order as well as the jurisdiction of the tribunal. The tribunal have the right to entertain the claims made by the buyer. This is the case law. The contention of the parties, the petitioner challenged the order of the council on the following grounds. The petitioner has said that he has not received a legal notice. That's one. The council failed to appreciate that respondent is a buyer under the MSME Act, and only the claims by the seller can be decided under Section 18 of the Act. Therefore, the council passed the matter without any jurisdiction. The respondent is a medium enterprises, ergo it is not entitled to invoke the jurisdiction of the council under Section 18 of the Act. The claims of the buyer cannot be independently decided by the council, and only the counter claims that it files in the response to the claims of the seller can be decided by the council. The scheme of the MSME Act 2006 does not envisage a buyer approaching the MSME Council for recovering any money from the sellers. The same is not contemplated under the MSME Act. The respondent countered the above submission on the ground. The Supreme Court in Shilpi Industries has categorically held that both the claims and the counterclaims are maintainable before the MSE Council. The MSME ecosystem provides quick adjudication and higher payment of interest, and therefore jurisdiction of MSME Council cannot be held to be barred. This was a counter argument made by the respondent, who is a buyer, in whose favor the MSE Council has made an order against the supplier. So, that as per Section 2(9) of MSME Act, claims and counterclaim are placed at the same pedestal, and therefore the distinction sought to be made by the petitioner would not be tenable in law. The respondent was a small enterprise at the contemporaneous time period when the dispute had arisen, the claim was made. That as per notification dated 18th October 2022 issued by the Ministry of Micro, Small and Medium Enterprise, even a medium enterprise can continue invoking jurisdiction of MSE Council for a period of 3 years after its reclassification. This is the counter argument made by the respondent before the Delhi High Court. Analysis by the court. What the court analyzed in this matter is, the court referred to the Statement of Object and Reason, SOAR, or the MSME Act 2006, and observed that it is brought to effect to support small-scale industries engaged in the manufacturing and extending the support in comprehensive manner to the services sector. It further observed that Chapter 5 of the Act is based on the provisions of the Delayed Payments to Small Scale and Ancillary Industrial Undertakings Act 1993, which was later replaced by the MSME Act, which was meant to create a statutory liability upon the buyers to make payments to the supplier. Court held that under Section 18, any party to a dispute make a reference to MSE Council in respect of any amount due under Section 17. Section 17 intends refer to Section 16 and Section 16 intends refer to Section 15. Thus, Section 15 to 18 of MSME Act 2006 are interlinked with each other and also linked to the and are also linked to the title of the chapter 5, Delayed Payments to Micro and Small Enterprises. Thus, the Chapter 5 applies only in respect of delayed payments to the micro and small enterprises. Chapter 5 excludes medium enterprises under Section 2G of the Act. The court held that Section 17 of the Act sufficiently addresses the situation, and a plain reading of the statute would reveal that the Act does not deal with a situation where a buyer raises claim against a supplier and makes it categorically applicable only in respect of claims recovered by the suppliers who are registered under the micro or small enterprises. Therefore, a buyer cannot maintain an independent claim against the supplier under the MSME Act. The bench held that the MSME Act does not contemplate a scheme for the buyer approaching the Facilitation Council under Section 18 of the Act for recovering any money from the seller. It is only the seller who can independently approach a Facilitation Council for adjudication upon its claims, but the buyer would have the right to make counterclaims. However, it cannot approach the Facilitation Council on its own. The court held that the amount due under Section 17 can only be amount liable to be paid by the buyer to the supplier and not the other way round. Thus, it is clarified that the language in Section 18, any party to a dispute cannot be extended to a claim by a buyer against a supplier, as the same is qualified as being only in respect of the amount due under Section 17. Accordingly, the court suggested the order of the tribunal. Okay, so the case is very clear. When the case is filed by the supplier, what the case is that if some supplier file a case that I have to receive 1 lakh rupees from the buyer, and buyer can make a counter claim that we have adjusted that amount or certain amount they have to pay. So we are making our counter claim that adjusting this portion, let him make my payment. So this is then counter claim which can be made at the time of proceedings. But for such a counter claim alone, the buyer cannot go and file a case before the MSME Council, number one. And MSME Council cannot be approached by the buyer. It is only made to safeguard the interest of the suppliers of MSMEs and the delayed payments made to them. So buyer have no right to approach the MSME Council. So this is clearly distinguished in this matter by the Delhi High Court, and Section 17 and 18 also very clearly stated by the High Court. So any doubt on this, you can ask to me.
In this particular section, I don't think we have a doubt. But as you mentioned that the micro and small enterprises are covered under Chapter 5, then where medium enterprises are covered, sir?
Medium enterprises, if you see the supplier definition, it says only the micro and small enterprises. The council name itself is called as MSE Facilitation Council. It is not a MSME Facilitation Council. This is to safeguard the interest of the Micro and Small Enterprises Council. Micro and Small Enterprises, the council is been established. So medium scale enterprises are almost big. So that's why they are not covered. They can go and file a case before the Commercial Courts Act. Okay. So here, a medium is not covered.
So may I ask one more thing?
Yes.
If the buyer have any complaint against the seller, then instead of approaching MSME Council, they can approach Consumer Forum.
No, Consumer Forum, they are not a consumer. Actually, Consumer Act is only applicable for the
right, sir.
goods which is used for a livelihood by the individuals, for its own livelihood, not for the commercial purpose. Here, these two transactions are for the commercial transactions. So in case the buyer have any problem based on certain agreements, it is not been implemented by the opposite party. then they can go and file a case under the Specific Relief Act before the court seeking for a specific relief. So the other party in the contract has not done their work. Okay, they are not fulfilled their promises. So they can go and file a case before the court seeking a specific relief under the Specific Relief Act or under the Indian Contract Act. Okay. Any doubt?
Thank you, sir, for clearing the doubt. It was not that relevant, but
Yes,
sir,
Sunil.
apart from this
Yes, sir.
discussion that we had today,
Hmm.
one thing that always came in my mind, that the MSME industries are getting benefits from the government,
Hmm.
lot of benefits. Then what will be their incentive to grow out of being an MSME industry and grow into a big industry? Because if they become a big industry, they will not be getting all the benefits that they were earlier getting.
See, these benefits are being provided for their growth. Once you have grown, why you want that benefit?
But sir, there are instances that where they do not have that initiative to grow, outgrow the status of a micro, small or medium enterprises, so that they don't lose the benefits. So
See,
there are instances.
if you register in the MSME Act as a medium also, you will be getting the tax. There is no need for tax audit. If a turnover is less than 10 crores
Yes.
and you are doing all the transactions through online. Less than 5% of the is cash transactions. 95% of your transactions are through online. So there is no tax audit report is required. So it is also further see if you are micro, small, medium scale enterprises, you are getting an electricity subsidy. What
Right.
is charged for others should be charged only 50% out of that. Even in the many state, if a company wants to go for an IPO, SME IPO, whatever expenses incurred by that MSME for going for an IPO, that is 50% out of that is reimbursed by the government of that constant state. So these facilities are provided for the growth of MSME sector. So the companies which are now being in a small and medium scale enterprises, now they have grown. There are a lot of funds have been poured into the company, and there are a lot of investors are there. Then they can migrate themselves to the main board of BSc and MSc, NSC. So the thing is that they should not remain as a small.
Exactly, that is the concern, sir, because then if the resources of the government will not be diverted to where it is needed the most.
Yes.
And if the industries which are categorized as MSME, if they are not willing to give up their title and
The title will go away, I will tell you. Once the turnover is crossed,
right, sir, but
automatically the system will
they
take
know how to restrict their
Yes.
threshold limit.
Once the turnover is increased, based on that increase in turnover and investment in plant and machineries, which they are filing before the income tax authorities and GST, the system in the Udayam portal will take that, it will automatically take that from that portal, add the link, so that their status will automatically get changed from micro to small. But whatever facilities they had at the time of micro, it will be continue for 3 years.
Yes, that is
So
the information.
for the 3 years, you can file a case, you can enjoy the benefits. Even within the 3 years, you once again reversed back to the micro, no problem. So after 3 years, also it continues to be in medium enterprises, then small enterprise status will go away. Your certificate will be generated as a medium,
Right.
not micro and small. Okay.
Thank you, sir.
Any doubts, Sunil?
I guess I have one.
Hmm.
So for instance, as we know, government has already provided some relaxations, or we can say less stringent regulations for SMEs for launching its IPO, and migrating to main board will be much more convenient.
Yes, it is much more convenient because initially, why you have to see. Actually, if you are a small enterprise, your compliance is very less. Okay, so when you migrate to smallness and above, under the company side, I'm telling you, your compliance will increase. So for certain period of time, you will be practicing how to do compliances in right time and everything. After that, it is a preliminary stage is before going to the main stage, you are converting yourself as a public. Okay, then after going into the public, and if you go for an SME IPO, you will be filing quarterly and annual reporting. Not sorry, half-yearly and annual reporting only, compliances. So that is a preliminary stage. Okay, you just acquainted with what are the, okay, these are the compliances. Now, once you go to the that is migrate to the main board, it is easy for you because already I did the half-yearly compliances. Now I want to do quarterly compliances. So it will become a habit of proper compliances and governance. So first step is small, then go for the main board. So firstly, you be a small and know what are the stock exchange compliances. Then if you feel that, okay, now I am eligible, okay, I can do all the compliances and do everything transparency and good governance. Yes, I want to go further. Yes, shift to main board.
Subject to eligibility and few conditions.
Conditions, and the company first, the company management has to make the mind. Yes, we can do proper compliances. Then we know compliance lessons because you are already following the SME exchange compliances. Additionally, you want to comply only quarterly compliances, we should migrate to the main board. It is just like in school stage before pre-college or pre-university. Once you go to the college, it is a matured thing. Once you become a main board company. Okay.
Thank you so much, sir.
Thank you. Thanks to all.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you. Thank you. Thank you.
Thank you, sir.
Thank you.